Mr. Patapon will not listen to the if it Patapon had with us. Not to get online or silver.
For delivery of orders, IS Civil 215424 in election petition 5 of 24 pertaining to Itanagar bench.
Okay, we'll take. No.
Was anyone there? The present interlocutory application, which was the issue of maintainability was raised, that has been dismissed. However, there was an order for making an inquiry regarding the adding of line of one line in serial number 21B in the checklist.
Right.
Oh. Sorry.
Item 3 for delivery of order IS Civil 855 of 25 in CRP IO 139 of 24.
Why is this two? Why is this three? Why is this three? Oh, 112. Present interlocutory application is allowed, directing the allowed and the extraordinary general meeting constituted on 3/4/2024 is allowed to function till the disposal of the miscase, and if it a direction to the trial court to dispose of the matter within 2 months, preferably within 2 months. Okay.
For bail hearing, item 1.
My lord, I'll straight away take your lordship to page number 21 and 22. And then
21 and 22.
There's a small write-up which it is given. There is a small write-up just when he was arrested, number of days in custody, and charge sheet is filed on such and such, charge framed on such and such, number of witness 9, witness examined 3, ground of bail is grounds of arrest not intimated, co-accused such and such granted bail, wide order dated such and such, passed in BA number such and such, page number 30 of the bail petition. The other co-accused is also granted bail, wide order such and such, passed in such and such, page 44 of the bail petition. And the third co-accused, my lord, just 2 minutes before, my lord, in court number 15, it was fixed for delivery of order and bail has been granted. Just 2 minutes before, it was fixed today. In the today's list, BA number 1675. These are my basic grounds, my lord. My lord, may kindly come to page 21 of my bail application.
In. A connection already been noted and for the function. That means same order of control. Because the earlier rejected your petitioners, it was earlier rejected by this court?
Yes.
By this court?
Yes.
Page 23.
Page 23. That is why it has come before the
Right,
lord.
yeah.
Those time, my lord, those pleas of ground of arrest were not taken.
Okay.
Page 21.
That's what I was just asking. You.
Yes,
This
yes.
time they are-
And you're for the page number 21.
21.
This is the memo of arrest.
Yes.
Okay.
My lord, I've seen, and my lord may kindly see page 22 as well.
Yes.
That's basically my case. And page number 30 and page 30 is the co-accused bail order. And in page number 13, this ground of arrest plea, your lordship will find at para 8, page 35. Para 8, page 35, your lordship will find the ground of arrest plea in the co-accused bail order, which starts from page 30. And the other co-accused granted bail at page 44. Here also, the ground of arrest plea, your lordship may find right from para 5, 9, 11, 12, 13. Those 3-4 judgments were discussed, my lord, and finally granted bail. So both, my lord, on Rehan Kumar, the ground of bail, as well as on the ground of parity, my lord, I wish to a small 1-paragraph judgment, my lord, of the Supreme Court, even on ground of parity, as well as ground of this is on ground of parity, my lord. That's my case essentially, my lord. Para 2 is on the ground of parity. That's essentially my case, my lord. I don't want to.
Otherwise, your petitioner is innocent.
My lord, innocent, my lord. A man is presumed to be innocent unless proven guilty, my lord. That is what we have read, my lord.
We have also read.
We were made to read that one.
And my lord, suddenly they have been agreed by
Yeah.
the non-furnishing of the grounds, my lord. Yeah, my lord, I rely on the, regarding the, my lord.
We have to file a representation before Honorable Supreme Court now.
Yes.
Once, there has to be one,
Lordship.
findings has to be there. Anyway,
Oh, one aspect just I'd like to indicate, both section 50 as well as memorandum of arrest in the LCR, I have
You have
flap
flagged
marked
it.
it with pink, light pink.
sure,
Pink color.
we'll see.
Right. Lordship, regarding the merit part, my lord, Lordship, may kindly turn to page 25 to 29, my lord. I am relying on these paragraphs, my lord.
25 to 29.
25 to 29, my lord. From para 6 onwards, my lord. Lordship, may kindly close. There is a materials against this petitioner, my lord. 6, 7, 8, 9, and 10. my lord.
6, 7, 8, 9.
Yes, sir. 6, 7, 8, 9, 10, and 10, 11, 12, 13 to 17, my lord. Lordship's order is there discussing the materials against them, my lord.
Rely on this.
Yes,
this
my lord,
line.
because, yes, my lord, because they
It
are
was the earlier rejected order.
rejected, and from this position, very much conscious position, my lord, they took more than 2 kg of heroin, my lord, has been seized, my lord. So as per section 37, my lord, the bar is there regarding the payment.
Yes, obvious.
And regarding the, my lord, that notice part, my lord, and also, my lord, 3 witnesses already over, my lord. So the trial is also continuing that in the smooth space.
Three witnesses have already been examined.
Examined, my lord. So, and that is also my long investigation is also, my lord, not to be taken up here at this stage, my lord. So that is one, my lord. Second part, my lord. And regarding the notice part, my lord, we day before yesterday, my lord, that we have taken the ground because it has been arrested, has been made prior to the
Pansal.
And I am relying on those, that is in the BA 1878, day before yesterday, and made on submission that
BA?
BA 1878 2025, that is pending judgment, my lord.
You have not delivered, I think. Yes, we have to, yes. Actually, I was not well yesterday.
Yes.
Today also, I'm not feeling so well, but somehow I have come.
Cover this case also, my lord.
Yes, we'll see to it.
Yes, and that is,
My lord, today the third co-accused, the fourth co-accused is granted bail today. That bail number I just want to give just 2 minutes before that judgment were delivered.
We'll try to.
BA number 2.
BA number?
671
BA number 1671/2025. And the date of order is today, 13/6/2024. And my lord, whatever this retrospective, prospective they say, in this case, the order at page number 44, the co-accused bail order, same plea was taken up. In this case, this honorable court has negated that plea. Because, my lord, there are 3 coordinate benches judgment, including your lordship, then Justice Court number 15, Justice Robin Foucault and Justice Nandi, my lord, this retrospective prospective that was not given effect to, primarily because Prabir Pukaisto was the later judgment than the judgment which they are relying for retrospectivity. The judgment which they are relying for retrospectivity is some Agarwal, Niresh. Ki Agarwal asile etu? Agarwal, some Agarwal judgment they are relying on for the retrospectivity. But Prabir Kumar is post Agarwal's judgment. That is more recent. And in Prabir Kumar, Prabir Pukaisto, para 47 is dot on that point. That it has to be in writing. And once the Supreme Court has said that, it is a law under 141 of the Constitution of India. Para 47.
No, as far I can remember in that judgment,
Yes.
in Pankaj Bansal, there is a word henceforth. So
Yes,
they are emphasizing the word henceforth.
henceforth.
That is difference.
My lord, they are saying henceforth it has to be in writing. That is post Pankaj Bansal.
Whatever,
communication-
henceforth, word
Yes,
henceforth is
henceforth
there,
is there.
and they're emphasizing on the word henceforth.
Henceforth. My lord, my respectful submission is that, my lord, this plea was taken in other two cases. In fact, the co-accused case, this precise plea was taken, but that was not negated. My lord,
And
negated.
we'll see to it.
I'm deeply obliged.
Another coordinate bench then who has accepted that opinion, that is also their mind. The losses may take losses on, what they may take.
এইটা ওলাই দিব এটাতো মোৰ লগত মানে মই দিয়া নাই আৰু এটা তেখেতে আজি এটা কিবা দিয়া বুলি কৈছে Pardon? মই কৈ আছো অলপ ৰ'ব।
Item 2,
Scan copy has not been received.
Scan copy received, madam.
Received.
On record.
But, in
This
the
is also on similar.
Has been received, yes.
received, but perhaps in late email, because in the cause list, it is not there.
It is not been.
It was in the office.
This is also, my
We have
lord,
not gone through.
Yeah, no, my lord, because it is reflected with the office note, my lord.
but I have gone through.
No, you may come through.
That may be some other,
Pardon?
that may be taken up some other day, this receipt.
Because nowadays we cannot fix any matter more than one because we have facing some problem. In fact, today also one hearing was there.
Yeah.
And in the middle of hearing, I have to be there because of this bench.
Yes.
So it is creating
Normally
actually
we,
problem. Normally we are,
Yes, go from the cause list, my lord. It has been indicated that it is
My
not
lord,
received. my lord.
basic issue is that the same law,
okay, then hit it fine.
arrest, illegal arrest, madam. There is no other ground.
But 19 days when we were actually interested.
I don't know why I'm like, if this bench continues, it will not. This bench will continue on 19 also,
Yes, the initiative to release as per to this rules.
as for today. And they tell me to visit and work by possible number that may be a job. So maybe fix on 19 We are checking the cross-checking the
Yeah.
listing field. Somehow, actually some Arunachal matter is also fixed on 19th. But we are trying to accommodate you on 19th.
19 will be some difficulty, my lord.
You have some difficulty.
It
Yes,
might
so
try
I
to
don't-
that, yes.
If not
How-
19, then
How it's after the mission. It is.
how many, we cannot say how,
How,
but
yes.
we are not facing
Then,
same problem. in fact.
No,
You're 18 to key, huh? Sunday, on the
It's already one.
1 meter is already fixed on,
it,
16, 17, 18 and 20.
all right.
any day, 16, 17, 18.
That's what she is saying. We're not going to fix more than 1 meters, in fact, otherwise it's problem again. Every day, same submission with the division bench and I have to leave
Yes.
any again. We have also problems. You have personal problem on 19th and 19 you have problem,
At morning part, madam.
morning part.
Yes.
You have problem in the morning hours.
Yes.
Obviously, it will be taken in the second half only. We're not sitting any morning hours here. It will be on second half
Okay,
and we'll try to accommodate you on second half only. Okay, the second half of note second half of Otherwise, we have some matters from Arunachal, in fact, through video conferencing.
Yes, there
We'll somehow we manage, and then we are trying to list it on 19th. If you have some problem in the first half, we'll keep it in second half only. And obviously, it will be second half only.
Okay.
List from second, 19/7.
Item 4 of the supply list, 4 and 5.
May I please, Your Rashid Khan.
Yes.
May I please? Okay. There are two bail applications.
Your
Madam.
objection you have already received?
Madam, yes, we have received the objection, madam. My lord, I am on basically, my lord, now Lordship has earlier rejected the.
Though two matters, basically your submission will be more or less same, I think.
Same.
Okay.
Both are same, my lord, the same grounds. And both the matters, my lord, the earlier your Lordship has rejected when they were during the investigation in 32 days. When they were in custody for 32 days, it was rejected, my lord.
Okay.
Now they are in custody for, my lord, 71 days today, my lord. In the meantime, my lord, charge sheet has been filed, my lord, already. So, my lord, my basic prayer before your lordship, this is a case pertaining to, my lord, disproportionate asset, my lord, the allegations. So, regarding disproportionate asset, my lord, everything related to, my lord, documentary evidence, my lord. Regarding. So, there is no chance of any tampering, and they have collected all the documents already, my lord, and they have submitted the charge sheet. Now, I have to defend myself before the court to rebut everything, my lord, the transaction, my lord. The charge sheet has already been filed. So, my release is very necessary to defend my case in the court, my lord, in these particular cases, my lord. Because I am only aware all the documents, my lord. I have to instruct the client also. So accordingly, my lord, I think, my lord, in this kind of cases, my lord, the release of the petitioner is very much necessary, my lord, to defend the cases, my lord. And this is a case, my lord, absolutely on the documentary evidence regarding the disproportionate asset. My lord, and apart from that, my lord, lordship kindly look into the one aspect, my lord, during the investigating period, my lord, in the FIR, in this first case, my lord, the amount they have shown as disproportionate was, my lord, 4 crore 53 lakhs, my lord.
In which one, which item?
This first item, my lord.
In number one.
In number one, my lord,
number 4, item number 4.
Item number 4, my lord, Masum Yusuf, my lord.
Mm.
They have shown, my lord, 4 crore 53 lakhs, my lord. In the FIR, my lord. And in their objection also, they have taken the same point, my lord. In E 3.3, my lord. 3.3 to 4.3. The investigating carried out and so far relief prima facie evidences acquisition of disproportionate asset amounting to 282% of his legal source of income more than 4.5 crores. They have also, but they have taken time to file the objection, my lord, on the last occasion. And after going, they wanted to go through the record also to file the objection. And unfortunately, the charge sheet does not say so. Now the charge sheet, the specific is that now the amount has come down to 170, my lord.
In CS. Charge sheet.
Yes. 1 crore 70. That is in the record, my lord. Probably, my lord, lordship can.
Okay.
In the page, my lord, charge sheet in our page 20. Paragraph 49 also. In the paragraph 49. I have a xerox of the.
Inner page, what is the inner page?
Inner page 21, my lord.
21, inner page, charge sheet or inner page 20? No, এটা তো order sheet, charge sheet.
They, in the inner page 20, they prepared a search chart, my lord, in the chart, my lord. And thereafter, my lord, paragraph 49, inner page 21. The now total amount that I have failed to provide a plausible explanation.
It was a page 20.
Paragraph 49, my lord, inner page 21.
Hmm.
That now I have failed to explain,
Hmm.
failed to provide the plausible explanation for acquisition of substantial asset worth of 1 crore 70 lakhs, my lord. So from 4 crore 50 lakhs, now it has come to, initially their case was that I have failed to explain regarding the accumulation of the worth of 4 crores 50 lakhs. Now it has come down to 1 crore 70 lakhs, my lord.
Okay.
Now, so primarily, my lord, that is the. So it appears, my lord, that their objection does not tally with the search sheet, my lord. Now, lordship, kindly see the grounds of arrest. Page 35, my lord. Why I was arrested. The main grounds of arrest is 3.
Page 35.
Page 35. They have alleged that I have accumulated the
Hmm.
rupees amounting to 4 crore 53. Then the 3, that is very important, my lord. You have failed to explain the satisfactorily the source of wealth and the asset which is significantly exceeded your legitimate earning. So ground of arrest was that I have failed to give any explanation regarding my accumulation of the assets. And this is the my lord forwarding report and the same forwarding report, and that's the ground of arrest. That is on 4/4/2025, my lord.
Hmm.
So in this case, my lordship, kindly see the FIR has been initiated, page 32. FIR is dated 3/4/2025.
Hmm.
That's very important. And lordship, kindly see there is a regular inquiry prior to the FIR, as per the FIR itself. In the
Possibly in one case, it was regular inquiry. The other one, it was not, I think.
yes, there's a no regular inquiry. Yes, lordship is absolutely correct. So there's a regular inquiry, number 8/25. So now I'll straightway, I'll not take much of your lordship time. See, what is the law regarding to the regular inquiry and how it has to be proceeded as per the government notification, my lord. My lord, there's a mandatory notification, page, my lord, 64, which is mandatory for all investigating agencies for this kind of offences, my lord. And this is not followed in this particular case, man. Absolutely, there is a violation. And this memorandum, office memorandum, is circulated and which is mandatory in nature because it has been on the basis of this memorandum has been prepared on the basis of the section 13 itself, my lord, because explanation has to be given to the suspect, my lord, an opportunity to explain. And if now lordship kindly see the page 64, and this is the notification 13 November 2009, my lord, page 64. In continuation of the office memorandum dated PLA, as your lordship got it, my lord, page 64.
Yes, yes.
In continuation of the office memorandum number PLA so and so dated so and so so and so so and so, memorandum dated so and so so and so, and after careful examination of existing provisions and with view to expedite the implementation of the vigilance and anti-corruption measures, the governor of Assam is pleased, the governor of Assam, my lord, lordship kindly see, Assam is pleased to order the following provision after sub-para section 3 of the office memorandum so and so for disposal of regular inquiry and initiation of the criminal investigation. So, it is the memorandum by Governor of Assam for disposal of regular inquiry and the initiation of the criminal investigation. Now, notwithstanding anything contained in the provisions earlier office memorandum in this regard, the inquiry officer through the Director of the Vigilance and Anti-Corruption shall collect detail of income and expenditure as well as other requirements as assets and liabilities from suspect officer employee. If suspect officer employee fails to respond to furnishing the required information, statement, etc. within 30 days from the date of receipt of the requisition. So there has to be one requisition prior to that. From the Director of Vigilance Anti-Corruption, Director of Vigilance Anti-Corruption shall move to the Government of Political Department. So then the department shall move to the Government in Political Department for approval of register a criminal case against the defaulting officer of employee. So this is the first. There has to be a requisition from the department concerned giving 30 days time to the delinquent officer. And if he fails within 30 days, then the criminal investigation can be initiated. Now let's next page, my lord. Provided that the Director of Vigilance, while seeking the required information from the suspect officer employee, shall inter alia specify the requisition letter that failure to furnish the information within stipulated period, that is 30 days, shall invite the process of registration of criminal case. So there is one more requirement that if you fail, then there will be a criminal investigation proceeding against me. There's a twofold in. First, there has to be a requisition. Then in the requisition also, it has to be mentioned that the failure on your part within 30 days to reply, that then there will be a criminal proceedings. Provided further that Director of Vigilance Anti-Corruption shall ensure the receipt of such requisition by the concerned suspect or employee against whom the registration of the criminal investigation is proposed. Now this notification has been issued to copy mark to page 66, my lord, to the Superintendent of Police, Chief Minister, Special Vigilance Cell, Janta Bhavan, Dispur also. Serial number 22. So all these department, all these, not only the vigilance, it is also mandatory for Superintendent of Police, Chief Minister, Special Vigilance Cell. They have to follow these guidelines, madam. Please. So there was no need why it has been issued to the their contention in the affidavit, the objection that they doesn't fall within the home, my lord. That can't be, my lord. It may be a separate entity, my lord, but this memorandum, because this memorandum was issued by the governor also, my lord. And copy was forwarded to them because it's a mandatory in nature. So in this case, now Lordship, they are saying in one way that this is indeed their objection, that this is not required for them. Then if that be so, now Lordship kindly see how they are playing with the law. Now, when I was in custody, page 69, then they have asked me submission of pro forma statement from number 1 to 4 relating to the vigilance PS RE case number 8/2025 regular inquiry. When I was in custody already, they have registered a case against me. I was already arrested long before. I was arrested on 4. After 26 days, when I was in custody, then they have asked me what? For submission of my statement regarding the regular inquiry. How can it be, my lord? Because on the basis of the inquiry, there has to be a requisition. They shall give it 30 days time to me. Then if I fail to satisfy their queries and my assets, then they can register a criminal case. Now, they have immediately registered a criminal case without giving me any opportunity, without giving me the notice, this particular requisition. Straightway they have registered a case, and during my custody, after 28 days in my custody, then they asked me to you submit the. How can in the custody from my, is it, my lord, this is the law, my lord? And the ground of arrest, what is the ground of arrest for me, my lord? That's why I have shown that I have failed to satisfy them regarding my accumulation of the assets. Whereas they have not given me the opportunity. When they have given me the opportunity, when I was in 28 days in the custody, when I was inside in the custody, then they have asked me to give the satisfactory. So absolutely they have put the cart before the horse. If I now explain, and the explanation from the jail is from their own investigation itself, within that period of short period, within that 28 days to 60 days, it has come from 4 crores to 170 without my explanation itself, my lord. Then your lordship can understand how it is going on, my lord. Without my explanation, it has come from 450 crores to 170. So this is an absolute violation of the mandatory right. But this cannot be an FIR. These FIR otherwise barred as far as the law, their own notification is concerned. They cannot register even the FIR without giving the opportunity to me. 30 days is the required time. You conduct the regular inquiry, no bar. But after regular inquiry, you must give an opportunity. You must give a requisition and the form. Specify. If I fail that, then yes, you register the case, arrest me, no issue. But it has to be, my lord. That has to be followed, my lord. Otherwise, how can it be, my lord? You'll arrest me, then you'll ask me to satisfy. This is what has happened. Exactly, my lord. You have arrested me without giving the requisition, and the ground of arrest, you are showing that you have failed, and subsequently you have issued the notification, and the objection is that this is not mandatory. If this is not mandatory, then why you have issued this to me? If this is not mandatory, then why you have issued to me when I was in custody? Absolutely absurd proposition, my lord. In the section also, that is this notification has been issued on the basis of the statute, my lord. It's not that this notification on the basis of the section 13 itself, because 13 itself says they cannot say that this is not mandatory, because it's a sanctity of the law. It itself says the explanation, a person shall be presumed to have intentionally enriched himself and illicitly if he or any person on his behalf is in possession or he has any time during the period of his office been in possession of pecuniary resources or property disproportionate to his known sources of income, which public servant cannot satisfactorily account for. From that proposition, my lord, that the opportunity should be given to the public servant, that there may be a possibility that he can satisfactorily satisfy the investigating officer. That's why this notification has been there. So then an opportunity should be given to him before arrest. So in this case, I have not given any chance to. And this is a mandatory notification, my lord, issued by the governor itself, circulated to all the department, including the CM Vigilance Cell. And they have followed it. But when followed, my lord? Subsequent to my arrest. So that's all. In both the cases, in the other case, there's no, absolutely no, my lord. It's not been followed. There's no state way. I've been arrested, my lord, in the other case.
Other case.
Yes. In this case also, there is an regular inquiry, my lord. It was 07, my lord. In that case also.
A regular inquiry was there.
Yes.
Acha, acha.
So in that case also, there is a regular inquiry on the same date, 3/4/2025. FIR was registered on the same day, my lord. Now, my next issue is that just a simple issue, my lord. Probably, my lord, when Lordship has rejected my bail prayer on the last occasion, probably they tried to impress upon your Lordship that I am asking for anticipatory bail. All the judgments cited before your Lordship, which has been reflected in the order sheet itself, and they are trying to project it like it's an anticipatory bail. Very surprisingly, Lordship, kindly see the order sheet. Order from 51.
Page 51.
Yes, 51, my lord. Now, from paragraph page 59, my lord. The citation they have placed before your Lordship, my lord. I am surprised, my lord. We have also relied some citation, my lord. These are all related to, my lord, 439, my lord. When person is custody. But the judgment they have relied, first one, paragraph 16, the P. Chidambaram, by the Director of Enforcement, so and so. Ordinarily, arrest is a part of the process of the investigation intended to secure the several purpose. There may be circumstances in which the accused may provide the information leading to the discovery of the material fact relevant information. Grant of anticipatory bail may hamper the investigation, my lord. Lordship, kindly mark it. The citation they have presented before your Lordship, it is connected to the anticipatory bail, my lord. I was already in custody for 30 days during that period, my lord. Definitely, my lord, the law relating to the anticipatory bail and the regular bail, there's a vast difference, my lord. There cannot be the same parameters, my lord. This is the first judgment they have placed. They are trying to impress upon your Lordship. Next one is again, my lord, Lordship, page 60. Second paragraph, observing the arrest is a part of investigating intent to secure several. The Adridhardan versus State of it was held. I'm just reading the fifth line from the bottom. Legality of the proposed arrest cannot be gone into an application under section 438 of the code. The role of it. So this is also 438, my lord. Now next, the most important judgment they have placed before your Lordship, that is, my lord, the Director of Enforcement versus Asif Kumar Jain, 1998 2 SEC. They are saying it is an economic offense. Now, Lordship, kindly read, let us read, my lord, what does the judgment says. The power under 438, again, being an extraordinary remedy, has to be exercised sparingly, more so in a case of economic offenses. The economic offenses stands in a different class as they affect the economic fabric of the society director of so and so, it was held that the economic offences accused is not entitled to anticipatory bail. It's also related to the anticipatory bail. All the judgment they have placed is regarding the anticipatory bail. How it is connected to a person who is in custody for 30 days. I'm not asking for the anticipatory bail. Next one, page 62, one more judgment. Eight point one, my lord. Observing the economic offence that constitutes a class apart and need to be visited in different approach is a matter of bail. Y.H. Jagan Mohan Reddy versus CBI so and so. The Supreme Court held as under. I'll not read this much. Next paragraph, my lordship, stateway page 83, point 83. Again, the grant of anticipatory bail at the stage of investigation may frustrate the investigating agency in interrogation of the accused in collecting the useful information, also the material which may have been concealed. This all judgment they have placed for rejection of my case, my lord, it was all related to anticipatory bail, my lord. And on the basis they have projected before your lordship that I was looking for an anticipatory bail, my lord. And for the economic offense, there is lots of cases that there, first of all, whether it is a public money or not, they have to establish that fact. But this is, their charge sheet, there's no indication that it is a public money, that I have collected public money from different sources. There's no charge in the FIR also, there's no charge under 13(1)(a). That means it's not a case of misappropriation of the public money, my lord. It's a case that I have acquired or enriched myself illicitly, my lord. That is the charge, my lord. But there, before that charge, there has to be an explanation from my side, my lord. If I fail to explain, yes, then there can be a FIR, my lord. So my humble submission at this stage, my lord, without going into much into the merit of the case, because already lordship has gone into the everything in the last time also, I am not on factually disputing anything. On the face of the record itself, it appears that from 4.5 crores rupees, it has in their own search sheet, without my explanation, it has come down to 1.7 crores.
That is for item number 4. Whatever is
I can either the other item, it is the same.
same. Okay.
Same. But the amount is same.
17.
In the other it is 79 lakhs, madam.
Not 79.
Yes, madam. 79 lakhs 42,000, madam.
Acha. Okay. Okay.
1.8.
1 crore. That's why I'm just asking. No, 79 lakhs directly. So frightening.
Total ekhini collect portion. Sorry, madam. Last line, my lordship, can I say page 29, my lord. Of item 5, my lord.
Item.
Page 29. After calculation, page 29, first line itself, madam.
Mm.
There is a calculation, and after he possesses asset to the tune of 14 lakhs 50,496, does he possess disproportionate asset? Lordship kindly see, asset to the tune of 79 lakhs, man. Has your lordship got it, my lord? Against his known source of income, my lord. It's not 1 crore, my lord. It is 79. That is from their record, my lord. Last conclusion is 79, my lord. So it was in the charge sheet, it was in the FIR. Now in the charge sheet, it has increased to, my lord, in the charge sheet. In the FIR, it is 79, my lord. But in the charge sheet, it was 1 crore 43 lakhs, my lord. So it appears, my lord, the calculation may not be correct. Prima facie, my lord. And in the second case, there is absolutely, I have not even served the requisition till today, my lord, to put forward my explanation in this case, which is otherwise also mandatory in this case also. So whatever may be the, my lord, proposition, my lord, at this stage, my lord, my humble submission that I am already in custody for 72 days. My further detention for the purpose of investigation is no longer required. Already charge sheet has been filed. Complete charge sheet has been filed. Now I have to defend myself also in the trial, because I have lost the opportunity in the beginning. I have lost the opportunity that is never given to me to explain myself regarding this asset. And I have straightway arrested on the date of FIR itself.
Yes. Yes.
So on that ground, my lord, I may be allowed to go and I'll leave it to your lordship, my lord. That's my humble plea.
But it is 4:45, man.
4:45, but we cannot give you any date because we don't have any date. That is the problem. Sum up your within 15 minutes.
Take some,
Try.
take some time.
Pardon?
It will take some time, madam. Take some.
No, your position you have already seen. That's what
I
just
understand,
I'm
ma'am.
taking the position. That's what I'm just explaining, because now up to 4:14, 4:15, I have to be there.
They have
so-
already filed the objection, my lord.
Anyway, let me go ahead then.
Okay, till 5:15 minutes, you can
I will try my way. I cannot.
try, and if it is not there, then we'll see to it. Okay, start.
So, now your lordship will find the basic argument before them, my lord. They want to say that initially in the FIR that they have enclosed, the forwarding report, and as well as the they have said that initially in the FIR it was stated to be 4.5 crores. Now it was reduced to 1.7 crores. Now, if you go to the charge sheet, your lordship go to the charge sheet, because what has happened in this case, my lord, many of the transactions were done through bank, UPI transactions. Deposits were made by a bank. Yeah, and it was deposited in the name of his mother, wife, and that way the money has been accumulated, while they were posted in different places.
No, but at the time of filing the FIR,
Yes, my lord.
when I just perusing the case diary in the earlier occasion,
Aye, sir.
I found that that was there only. When you have assessed the disproportionate assets was counted to 4.5. In that time also, the situation was there that they through bank transaction, they were.
But then some land documents were also there. That was most probably they could not collect. Transfer was not done most probably. That we cannot say now, because we have to go by the documentary evidence. What is document that has been collected during investigation? So basically, it is based
So
on.
now what do you want to explain regarding the reduction of or this coming down of the?
Depend on whatever transaction has taken place, is that shown in the bank details, my lord. The UPI transactions were there, and actually what happened to his parcels were employed by them, my lord. The money has been collected by them, and they deposited through him. So we apprehend that those persons who are working under him, they may be influenced. That is the most important. Because all the amounts were collected by them. And they used to deposit in their family account. And ultimately it goes to them. So there is a nexus. Right? And those were made as witnesses in this case. That is another aspect, my lord. And one more thing that they have argued, my lord, that if your lordship take up that office memorandum, so they have relied upon this office memorandum. That office memorandum that is annex page 64, man. That is 2009, man.
Hmm.
Now, my submission with your lordship, my lord. So what is the first memorandum is concerned, is it not a bar as such, that without giving an opportunity, providing an opportunity, without issuing a notice to him, he cannot file any case.
And say it cannot be a bar, it's
It-
not a mandatory.
Not a mandatory. Because your lordship will find there is a way back, our High Court decision, the Supreme Court decision is that executive instructions, my lord. Executive instructions conveying the policy decision cannot supersede the statutory rules. Because statute is very clear. Section now 154 has come, 173. And BNSS, my lord. Because this is a offense.
BNSS,
Yes.
which section?
One 173 is the BN assessment. But subsection 1 says every offense relating to an offense commissible. That is, now it is 154 has come 173.
Oh, okay. Yes.
Every 173 1 says every information relating to the commission of cognizable offense, irrespective of area where the offense is committed, may be given orally or by electronic communication to an officer of the that is different issue. Now am I coming to straight to subsection 3, man. Without prejudice the provisions of section 175 or receipt of information relating to commission of cognizable offense which is made punishable for 3 years or more or less than 7 years, the officer in charge of police station with a prior permission of officer not below the rank of DSP, considering the nature and gravity of the offense, proceed to conduct a preliminary inquiry to ascertain whether there exists a primary basic case for proceeding in a matter within a period of 14 days. Proceed with investigation to exist a primary case. Then now an officer agreed by the refusal of part of officer in charge to record the information. That is different part. So when there is a inquiry has been conducted, so preliminary inquiry, that preliminary inquiry, if they found a primary case, then they are duty bound to lodge an FIR. And that has been held by Lolita Kumari also, that it is a settled law that when there is a preliminary inquiry on the basis of information received, there is a preliminary inquiry. After conducting the preliminary inquiry, if they found a cognizable offense, and then the police can register a case under appropriate section of law. In fact, I like to rely on decision of Supreme Court, my lord. That is 2007 13 SSC page 606. 2007. This matter relating to remission of a power of remission in case of convict matter. There your lordship will find, and it has been discussed in paragraph 39, matter. That is page number 619.
Hmm.
It is now well settled. Any guidelines which do not have any statutory flavor or merely advisory in nature, they cannot have a force of statute. They are merely subservient to the Legislative Act and statutory rules. Then paragraph 40, when a policy decision is made, persons must be treated equal terms. There is a difference. So this office memorandum has been issued by the governor, by the executive order. So it cannot supplement or it cannot go against the section 153, man. So it cannot be said that it is a bar as such, that without complying this office memorandum, we cannot register a case. even there is a violation of this office memorandum, my humble submission with you about it, there cannot be any bar for registering a case. Now, what has happened in this case? Because mostly in the case that there are GD entries to the effect that on the date of arrest, he was arrested on 4 arrested. Then on number of occasions, the investigating officer asked about the bank deposits because these are matter of records. He remained silent. Second deposit, the name of his wife, the name of his mother, how they have come, is totally silent. And ban a person, his income is around only 50 to 60,000. But his deposits are more than crores. From where they have come. And there is no explanation to the matter. So now the question that has been raised by my friend, my lord, that no opportunity you have given to him, that there is a violation of section 31A of the PCA. Because
No, this you are saying from case diary.
yeah,
That is during the preliminary inquiry conducted
Not
by
a preliminary.
after arrest.
after arrest, he was then he was
how
found the
come-
deposits, my lord. Regarding that, he doesn't give me an answer. Man. That so much
No,
amount has
no,
been
no.
deposited.
The question is that Mr. Bora was raised the issue
Yes, ma'am.
that okay, then you as per you, it's not mandatory or whatever. But the question is that whether you have given any opportunity for explanation, that is his issue. But now you're raising that, no, you were giving some many occasions, it was asked him, but he did not give any reply to the regarding the bank accounts and all.
From investigation, while
This is
investigating,
after registering your case.
yes, ma'am.
That's what I'm asking.
Now the question is that is it required, man? In a case of disproportionate asset matter,
Yes,
disproportionate.
you can.
Disproportionate matter because there is a yes. The citation I'm not brought the copy. There is a constitution bench judgment as far back in 91 3 SCC page 655.
Is it for anticipatory bill or regular bill?
Not a page. This is a question of law.
Just I'm asking for my satisfaction. Maybe-
It is not a question of value.
Okay. I'm just wanted to know.
There's a constitutional judgment K. Veeraswamy versus Union of India. There you are also at that time that 1947 Act was there. Same language. Yes, my love. I explained a particular paragraph. I'm giving you the section clause E, my 5(1)E was there. Clause 1 creates a statutory offense which must be proved by the prosecution. It is for the prosecution to prove that the accused or any person on his behalf has in possession of pecuniary resources or property disproportionate to his known source of income. When onus is discharged by the prosecution, it is for the accused to account satisfactorily for disproportionality of the properties possessed by him. This action makes available statutory defense which must be proved by accused. It is a restricted defense which accorded to the accused to the account for disproportionality of the assets over income. But legal burden of proof placed on the accused is not so onerous so as the prosecution. However, it's not just throwing some doubt on the prosecution version. Legislation advisedly use the expression satisfactorily account for. Then the offenses must be word satisfactory means accused has to satisfy the court that his explanation is worthy of acceptance.
Yes.
That the burden of proof placed on the accused of evidentiary burden, though not a persuasive burden.
Yes.
Accused, however, could discharge the burden of proof on balance of probability either from the evidence of prosecution or evidence of defense. So, when our burden is so that this much of evidence has found to be disproportionate. So then the burden shifts to the accused to prove that by way of preponderance of probability that.
So in that case, not in the inquiry stage, but it is stage of evidence or
Right.
trial.
He was a former High Court judge of that, Madras, it's a famous case. There whether he can be prosecuted or not. On that point, that it was discussed, my lord. I'm giving the judgment. So now he says, my lord, the procedure may be contrary to well-known principles of criminal jurisprudence. Laid down in Willington versus Director of Public Prosecution. The burden of proofs always lies on the prosecution, never shifts to the accused. But
Yes.
Parliament is competent to place the burden on certain aspects of the accused, as well as particularly matters especially within the knowledge. Prosecution cannot, by the very nature, things be expected to know the affairs of a public servant found in possession of resources disproportionate to his known source of income. It is for him to explain. The such statute placing the burden on which cannot be regarded as unreasonable, unjust, unfair, nor it can be regarded as contrary to Article 21 of the Constitution. The principle reaffirmed in Willington case is not an universal rule to follow in every case. Principle is applied only in case of statutory provisions to the contrary. If the prosecuting agency, after making suitable inquiry, after taking into account relevant documents, which the forms opinion the accused cannot satisfy for accumulation account, then 551 is attracted. So during the investigation, if we collect any documents or any whatever materials we collect, we form the opinion, yes, there is a case of disproportion. Then we will file charge sheet. We will adduce evidence. Then the burden lies on them to show that no, it is not a case of disproportion. My income is that, and it covers Yeah.
Not burden, it's onus.
on us. What burden shifts?
Burden never shifts, only the onus shifts.
106 will come into play.
Burden never shifts, only onus shifts.
So it is not a case that what he has stated that earlier in the point of time he has to give me an explanation. That is not the law. And we were in our affidavit also, in our bail application objection also, we have stated, my lord, the percentage that has been come, that it was more than 300 because his income is around 50,000, 60,000 per month, my lord. And
Where, in your affidavit?
in my objection, my lord.
Ah.
The percentage that has
Percentage you have already, in the, there was also calculation was there, I
Yeah,
think, yes, regarding percentage. No, obviously, that is your case.
Yes.
His income was that and the
So,
proportionate
now
property,
question is that-
it is disproportionate.
Yeah, now the question is because of highness of these particular these brothers in arms, I could say, because they are a circle officer. Only 5 years of service, man. And 5 years of service, they accumulate so much of wealth, which doesn't have any explanation now. They have used the accounts of his wife, their mother, man. And money has been paid through their various accounts.
Mm.
And that has been accumulated, man. And
Because for circle officer, it is easy also for various things are there also through them also they were acquiring the money and not property.
so, and they have used their own subordinate officers. well.
That's what I'm saying, own subordinate. officer.
As we apprehend that, those subordinates were during the trial may be turned hostile.
Turn hostile. Achha.
That is the
one of
basic-
the.
one basically. That is the possibility. man.
কই দিয়া নাই কিয়? ইয়াৰ এলেকাৰ মানুহ। দম আছে।
দম আছে, ক'ব পাৰো কি
কোৱা
আছে।
নাই, কোৱা, কোৱা।
Because those members, actually, he wants to say those members were employees.
I'm not saying,
Belong to
This is
minority community.
He said, Malak, this is not my, he said, Malak, why not?
কৈ দিয়া, কৈ দিয়া, কৈ দিয়া।
I said that if you are arguing, you say it. If you
Belong to
are saying-
minority community, so they are there.
This is absolutely, my lord. I cannot, my lord, endorse to that proposition, my lord. That cannot be, my lord.
So
He's inviting trouble, my lord.
what I mean.
There may be a case also, my lord.
Yes, yes.
Tomorrow, that this is absolutely, my lord.
Anyway,
Nowadays, everything is live, so.
Yeah.
So considering the gravity of the offence, madam, we are objecting the bill application, madam, and enormity of the amount and the modus operandi of collecting the amount. It goes to root of the matter and the society also, madam. And further investigation still going on, my lord, to collection of the required documents to connect this from where they have collected the amount. my lord. So considering the nature and gravity of the offence and basically, and being a circle officer, they have gone to such the extent, my lord, illegality perpetuated, my lord. And they committed and collected so that's a huge amount, where there is no explanation at all. So my humble submission that bail application is liable to be rejected, my lord. Since trial is yet to commence, my lord. Only cognizance has been taken. On the next day, we are supplying documents. So with charge will be, so within the
As a whole, how many witnesses you have cited in maximum witnesses?
that's
Around 16, 17 or more than that? Because some of subordinate staffs are also there.
Now 37.
87.
particularly bank officials and the other officials, man. The Caesar documents, man.
That means, my lord, these are the official witnesses.
Uh,
He said, my lord,
This
that these are the official witnesses.
of,
And he has apprehending that these official
Yeah.
witnesses may turn hostile.
yes, this of the working under you only at that point of time.
So the
The
in,
bank officials may not turn hostile, but your officials, which are under you, they may turn hostile.
presumption, my lord.
That's what I'm saying.
my lord. How they can, this is their witness, this is not my witness, I am in custody. If they say that these witnesses, which they have cited, which they have relied to
Because-
put me inside, now they are saying they may be hostile tomorrow. It's an anticipatory, my lord,
Because
kind of an evidence they are relying on, that tomorrow something may happen, so he must be inside the jail. So this is a kind of a hypothetical situation, my lord. On the basis of a hypothesis, can my right can be curtailed on a hypothesis on the basis of an anticipatory evidence? There is a case of a Suresh Das, my lord, very famous case of 1971 ALR, if I am correct, my lord. And I have learned it from him himself, my lord, in long before, my lord. In that case, and the doyen of a criminal case, his father, he argued in that particular case, on the basis of an anticipatory evidence or hypothetical situation, you can't even frame charge, you can't do anything. Now they are saying that
Framing
under
of
that
charge.
tomorrow, these people
we
will
are-
become a hostile. And the 37%, he says, these are all bank officials, my lord.
Not all, fine.
And Lordship kindly see, in the charge sheet, Lordship will go through, in the FIR, there is an allegation that they have paid some money to my account, my mother's account, but in the charge sheet, there is no such allegation.
Because there's
There is
one.
no such allegation.
Most probably there was a allegation. because
Yeah,
there are
Sajid Shah,
some-
my lord. Sajid Shah.
Huh?
The one witness, Sajad Shah.
Ah,
He says, my lord,
And then why not the 164 statement, my lord?
he says,
If they are apprehending, my lord, that they may turn hostile tomorrow, they say that these are the witnesses, they may turn hostile, then why don't you record the 164 statement before the magistrate?
because I approached by the family members of Tanvir Yusuf Ahmed to request that I give a statement before police in their favor, are falsely claiming that we had paid rupees 20 lakhs to my sister Salman. That is a difficulty, my lord, because all family members were also involved, my lord.
But in the charge sheet, there is no such allegation. Lordship will go through that charge sheet. Whatever he has submitted, that there is no charge sheet. In their charge sheet, that kind of allegation has been negated, my lord. So I am just relying, my lord, replying to these few points, my lord. The first of all, he says, my lord, this is not a mandatory requirement. This notification is not mandatory. Just I am asking again and again to myself, my lord. Then if it is not mandatory, then why you have issued that subsequent notice to me to satisfy that the 69, the submission of pro forma statement, why you are asking for the pro forma statement from me to satisfy how I have accumulated the asset. And it is that particular notice is under regular inquiry of 08. On the basis of which inquiry the FIR has filed. Then they are saying, their lordship, that the judgment he is relied on, that is goes in my favor, the Viraswamy judgment. The Viraswamy judgment, the first line itself is that, first of all, the burden on the prosecution, they have to satisfy. that burden will shift to me. Yes, definitely presumption, because there's a presumption against me. Then these kind of offenses, there's a onus on me, but that onus is not so high as prosecution. My is just an rebuttable presumption, and he said it doesn't have the statutory prescription, my lord. This particular, it's absolutely wrong, my lord. The lordship kindly see this office memorandum he is saying, he is relying on the BNSS. I'm not relying on the BNSS because BNSS is it is general law, my lord. This is a special law under the PC Act. So this will prevail, my lord. And the PC Act says, and this notification on the basis of the section 13 it has been issued. Why this notification has been issued? Why this the regular inquiry? Otherwise, where is the provision in the BNSS, the regular inquiry, my lord? Where is the provisions of the preliminary inquiry in the BNSS? No. But in this statute, my lord, in the under the this Prevention of Corruption Act, the section 13 itself says, because the satisfactorily, when there can be an offense, the offense only then can be a person shall be offense. I'm reading again, to have intentionally enriched himself illicitly if he or any person on his behalf in possession of the so and so pecuniary resources, property disproportionate to his known source of income, which the public servant cannot satisfactorily account for. So, if I fail to satisfy, so this may be during the trial, but a opportunity, why this opportunity is given under the by this notification? Then why you have issued the notice to me if it's not the mandatory, and that too in my custody? What was so necessity? If it is not mandatory, why have issued it? One way you will issue a notification under the statute, and one way you will say this is not notice, this is not a mandatory. You decide one. You can't have the cake and eat it too. And the next point, my lord, the Veerasamy judgment, my lord. The first line itself, it goes in my favor. The onus has to be discharged by the prosecution, first of all. Now, what is their onus, my lord, here? And if I fail to satisfy, in every judgment, if I fail to satisfy, but here, without giving me the opportunity, during the inquiry, whether they have issued any notice to me during the inquiry in the case diary, they can show it. No, they have never. Whether I knew it that there is an inquiry pending over me, no notice. Then suddenly over a night, FIR was registered, and the next day, they will say me, they will arrest me, and they will, in the arrest memo, they will say that I have failed to satisfy how I have accumulated. And thereafter, after 20 days, when I am in custody, then again they will say that you satisfy now. In relation to the inquiry which is pending. Absolutely flabbergasted proposition, my lord. Absurd, my lord. If I explain during the inquiry, what happens, my lord? Suppose you give me the chance to explain the inquiry in the inquiry. If I can satisfy, then what will happen, my lord? I have lost the job. Now I am suspension, my lord. I have lost the reputation, everything. And they are saying, and regarding the initially 4 crores, 4.5, how it has come down to 1.7. This is in the search sheet itself, my lord. Even without my explanation. And the explanation given by my learned friend, it's beyond my understanding, my lord, what he wanted to see. These are allegations already there. Lordship has rightly pointed out. Those allegations are already there during that when I was arrested, when my bail petition was pending during the investigation. After the calculation, they have come out to 170 without my explanation. So now, and they have failed to, they are saying why my bail should be rejected because I'm an influential. I have been already been under the suspension, my lord. I'm not so high officials, and these are the all officials, my lord. Lordship can see who are the person, my lord, and they are on the basis of an anticipatory presumption that the people may turn hostile. Your own witnesses, you are saying that they may turn hostile. That's why my bail application should be rejected. Can it be a proposition, my lord? I have never heard of this kind of proposition, my lord. Absolutely absurd proposition, my lord. And these witnesses, as per the charge sheet, my lord, what I can see, they will only prove the document, my lord. This is not a case of a murder, my lord, that they can turn hostile, my lord, anytime. So the man may lie, but the document will not. The lordship can see the charge sheet in the last page. These days, the witnesses only prove the document. Their own column that these witnesses will prove the documents. Then how, if the documents they were coming to prove the documents, how they can belie it, my lord? This is absolutely, my lord, just to deny my bail. These are the submission made by my lord. So my lord, but this is an absolutely fit case because I have to defend my lord in this trial, my lord. They have said that the cognizance has already been taken, and charge sheet has been laid down. And on the basis of the further investigation, if they have not completed the investigation if this is not a complete charge sheet, my lord, they say that the further investigation is still going on, then also I am entitled for bail, my lord. How long they will carry for the further investigation, we don't know. On the name of the further investigation, can you put me behind the bar for the unaccounted period, my lord? That can be, my lord. When the charge sheet is, always my custody is required during the investigation only. Investigation is completed. You file the charge sheet. Matter is a documentary evidence. And the statute says, my lord, that presumption only comes when I fail to satisfy. The word everywhere, if I fail to satisfy, my lord. And in memorandum also, the office memorandum is very specific. And whether they have challenged that particular memorandum, that this is not a correct memorandum, my lord, why the state has not challenged that memorandum of the governor, that this is not under the law. They ought to have been challenged that particular memorandum, my lord. It is your memorandum. The governor has issued the memorandum, and the memorandum specifically says that the 30 days time ought to have been given to the delinquent officer to satisfy. If he fails to satisfy, then only the criminal case should be initiated, man. Only then. Why the copy has sent forwarded to all the officers, why it was not challenges that this is not the correct proposition of law till date, because it is the law, because this is the sanctity under section 13(1). 1D, my lord. It's from the statute itself, my lord. That's all, my lord. I leave it to your lordship.
It would not be. It would. See if you can see what this is. Page of activity. Is there no piece of information to be? Is there even a record of that? I'll pass you out. Oh.
Much obliged.